or what conduct can be relevant. And so section 10 is applicable only when there is a conspiracy. So section 10 is a typical section that is applicable only when there is the conspiracy under section 120 capital A, and punishment is 120 capital B of the Indian Penal Code. And the scope of the section 10 is also very wide. So anything that is said, any act that is done, any written statement by any of the co-accused in the conspiracy would be relevant, and it can be used against the other person. Maybe that statement is made before the person who is on the trial, or before or after that he left. But the statement has to be made by the person when he is in the conspiracy. Okay. And on that we have discussed three cases. The first is the Privy Council judgment, if you remember, Mirza Akbar versus King Emperor. The second was Badri Rai versus that Badri Rai, and the third was that state of Calcutta versus I just give me one, Muhammad Khalid. So Muhammad Khalid. And in all these three cases, we had the discussion on the scope of the section 10, and from there we can deduct that the first thing is that there has to be a prima facie evidence of the conspiracy. The section 10 starts with reasonable grounds to believe that there is a conspiracy. The second thing is that in that case, when there is the prima facie ground, anything that is said, any act or the written statement would be relevant if it is made by a person who is in the conspiracy. The third is that this statement is in reference to their common intention. And the fourth one is that it has to be made before their common intention ceases to exist. And you can say that before the first their common intention is formed, after the first their common intention is formed, and before the common intention is ceased. So the statement by any member of the conspiracy after his arrest or after he ceases to be the part of the conspiracy would not be relevant. And this statement can be used against the co-conspirator. Maybe that co-conspirator joined the conspiracy later on, but the statement is made by the person who is part of the conspiracy. Okay, so here there are two things. The person who is making the statement has to be within the conspiracy in reference to their common intention, and that statement can be used by any person who join later on. Okay, so ये जो हमने कहा ना कि it has to be when the common intention is first formed and before it ceases to exist, it is applicable to the person who is making the statement, whose act is declared as relevant, or whose written statement is in question. Okay, this is thing. So with that, there is another case in our case material, and though this case is discussed under the admission, but there are three things that are important in that case. The name of the case is Central Bureau of Investigation, CBI. You have to listen it very carefully. CBI versus VC Shukla. VC Shukla was a famous politician. More than 6 decades, he was in active politics. And another famous name in this case is known as L.K. Advani, Lal Krishna Advani. And this case, CBI versus VC Shukla, is popularly known as जैन डायरीज केस, हवाला स्कैम केस, बड़ा हवाला होता था. ओके, देयर वाज ए जर्नलिस्ट विनीत नारायण, and this journalist Vinit Narayan was anti-corruption crusader, or you can say anti-corruption activist also. So he filed a public interest petition, public interest PIL, public interest litigation, in form of a petition in the Supreme Court, and then the case started. CBI did the investigation. Now, the important things in that major politician Lal Krishna Advani, Devilal, VC Shukla, many other persons who are from various parties, they were accused in the cases related to Vinit Narayan PIL, and unfortunately all will be acquitted by the court. किसी को भी सजा नहीं. This is the system in our country, that in this famous Hawala case, no one was convicted. This is a big case. Now come to see this case from our perspective, those 5 parameters, or you can say the things that we have to observe in this case. The first is about the facts. Facts are very simple and interesting. CBI start investigation, the PIL file with the CBI in investigation start की, and they raided this JK Jain house situated in Saket. साकेत का जो इलाका है उसमें मिस्टर जेके जैन का हाउस था. सो उसमें सीबीआई ने रेड मारी, एंड दे फाउंड 2 डायरीज, 2 small notebooks, 2 foil containing detail of recipient of various amount from different sources. So CBI has recovered 2 डायरीज, 2 स्पाइरल बुक और कुछ अलग फाइलें जिनमें डिटेल था कि कहाँ से पैसा कितना आया, किस पॉलिटिशियन, किस बड़े लीडर के पास, किस बड़े डिप्लोमेट्स के पास, पब्लिक ऑफिशियल के पास ये पैसा गया. एंड देन द 3 Jain brothers, Mr. S.K. Jain, B.R. Jain and N.K. Jain. These 3 Jain brothers were the middlemen. इनका काम क्या था कि जो इंडिया के जो पावर सेक्टर था उसमें जो टेंडर्स होते हैं, तो उस पावर सेक्टर में बड़े बड़े प्रोजेक्ट दिलवाने का ही काम करते थे. तो फॉरेनर कंपनियों को ये लोग एज ए मिडलमैन प्रोजेक्ट दिलवाते थे. प्रोजेक्ट तो पॉलिटिशियन के थ्रू मिलेगा, तो उस डिपार्टमेंट के जो भी वो बड़े ऑफिशियल हैं, उसमें जो मिनिस्टर्स हैं, उनसे सब पैसे ट्रांसफर करते थे और उनसे जो है विदेशी कंपनियों को प्रोजेक्ट दिलवाते थे. एंड द मनी हैज टू फ्लोन थ्रू द हवाला. ओके, so this was whole the black money, and then the different politician, different public official were the recipient of this money. And in the servant of these Jain brother, ये तीनों जैन थे, एनके जैन, एसके जैन एंड बीआर जैन, और इनका जो सर्वेंट था मिस्टर जेके जैन जिसके घर पे रेड मारी, वो भी जैन ही था. उसके घर पे इन सब का काला चिट्ठा मिल गया, इन विच देयर आर द रिकॉर्ड्स व्हेन द पेमेंट इज मेड, टू whom दिस पेमेंट इज. भाई हिसाब तो रखना पड़ता है ना, हिसाब तो सब लोग रखेंगे. देन what happened that the CBI, after the investigation, taking the statement, filed the charge sheet. And in that charge sheet, because the name of Lal Krishna Advani was also there, VC Shukla is also there. So this case is basically, this appeal is related to VC Shukla and LK Advani, in which some amount is shown to be given to VC Shukla and Sri Lal Krishna Advani, who was the member of parliament at the relevant time. And the prosecution has now frame a story. What are the prosecution story? So the prosecution story is that these three Jain brothers are the middlemen, and they are in the business. They are in the habit of assuring the big projects in the power sector by bribing the public officials and the ministers. And in that, there was a conspiracy between these three Jain brothers and LK Advani and VC Shukla also to allot the power project to these companies from where this money has flown to the India. And if you see the whole transaction, this was in the crores. Okay. Now, the court also framed the charges. The stage hota na charges of CRPC, you will read it. And when the charges are framed that under the Anti-Corruption Act, Section 7, Section 13A, D, etc., Section 12, Prevention of Corruption Act, and Section 56, read with Section 81 of Foreign Exchange Regulation, now it is FEMA. So these sections were imposed. Section 120B IPC and Section 13.2 read with Section 13.1 D, 7 and 12 of the Prevention of Corruption Act. Charges were framed. Now, these are the facts. Facts are over here. Isse zyada koi fact nahi. Now come to the second point. First is facts. Second is case history. Third is issue. Fourth is arguments. Fifth is decision. उस हिसाब से हमें केस पढ़ना. Now the case history, that how this case reached to the Supreme Court, because the judgment that you have in your case material is Supreme Court judgment, CBI, Central Bureau of Investigation versus VC Shukla, AIR 1998 SC. SC means Supreme Court 1046. So what happened that when the charges were framed, trial was not started. These person approached to the High Court. सर हमारे साथ तो अन्याय हो गया, बिकॉज हमारे खिलाफ तो चार्जेस फ्रेम हो गए प्रिवेंशन ऑफ करप्शन एक्ट में, और अगर ट्रायल भी चल गई या और भी आगे चीजें हो गई, देन आवर पॉलिटिकल कैरियर विल बी डिस्ट्रॉयड. सो प्लीज क्वेश द चार्जेस, एंड द क्वेशिंग ऑफ चार्जेस एज सच देयर इज नो स्पेशल प्रोविजन. सेक्शन 482 of the CRPC talk about inherent power of High Court. So under inherent power of High Court, when there is no special provision, जब कोई ऐसा प्रोविजन नहीं हो, कोई स्पेशल प्रोविजन नहीं हो जिसमें रिलीफ मिले और उसके अपोजिट भी ला ना हो, तो आप हाई कोर्ट में जा सकते 482 में, बिकॉज वो इनहेरेंट पावर है. इनहेरेंट का मतलब कोर्ट का काम है न्याय देना. अगर कोई प्रोविजन नहीं है तो इसका मतलब ये थोड़ी कि न्याय नहीं देगी. Are you getting my point? So under 482, they approached to the High Court for questioning the appeal, and then High Court is under challenge in this appeal at the instance of the CBI, because the High Court has said quash the charges, and so CBI approached to the Supreme Court, because who is the aggrieved party? CBI. And before the CBI, there are questions that the relevant evidence that you have about the Jain diaries record. There are three things or three sections of the Indian Evidence Act under which these diaries entries are relevant. One is under section 34, the record of the business transaction. The another is that if you prove that there was something conspiracy, then these are the statement made by conspirator during the conspiracy existed about the account, how they did, how many money was flown to this person. So that section 10 is, and the third one is that it is confession. And if it is not confession, it is an admission about कि उन्होंने पैसा एलके अडवाणी वीसी शुक्ला को इतना दिया, इसका तो एडमिशन मानो जज साहब. Now we are not concerned about section 34 and admission part. We will discuss later on, and we will discuss case on that aspect. The question, the issue here is that whether under section 10 of the Indian Evidence Act, the entries in these diaries would be relevant or would not be relevant. Or in the simple word, you can say whether section 10 would be applicable or would not be applicable. Now, if you have the case material in hard copy, because some students get it print out, so or if you are reading through this soft copy, from page number 54, para number 46 to para number 51 is the relevant discussion on the applicability of the section 10. The court has observed that if we read section 10 as we have already read, so why to repeat that? And if we see the law laid down by Supreme Court through the interpretation on section 10 through Mirza Akbar, Badri Rai, Sardul Singh versus State of Bombay, Bhagwan Shavam versus State of Maharashtra, for proving section or for making some statement, some act to be relevant under section 10, para is from 46 to 51. Udichi, paras are from 46, 47, 48, 46 to 51. 46 है, उसके बाद में पैरा का नंबर भी गायब है. 46, 49, 50, 51. Okay. Most important is the 46, that the law has been discussed, and on that law, then that has been applied in the para number 50, and it is on the page number 54. So para number 46, 49, 50, 51, page number 54. Okay. So yeah, so the Supreme Court said that latest in 1965 in Bhagwan Swamp was a state of Maharashtra, the court analyzed the section as follow, and then you will find the 5 points about the section 10. I'm reading those. You also has to read. There shall be prima facie evidence affording a reasonable ground for the court to believe that 2 or more persons are member of conspiracy. The first is that there must be some reasonable ground to believe that there was a conspiracy. The second is if the said condition is fulfilled, anything said, done, written by any one of them in reference to their common intention will be evidence against the other. The third is anything said, done, or written by him should have been said, done, or written by him after the intention was formed and before it was ceases to exist. It would be relevant for that purpose that against another who entered in the conspiracy, whether it was said or it was done, written before he entered into conspiracy or after he left it, it can be used against the co-conspirator and not in favor. So like the admission cannot be used in favor of the person who made it. Under section 10 also, the statement made during the conspiracy in reference to the common intention also has to be used against the person who make it, not in favor. ऐसा नहीं कि आपने एक चिट्ठी लिख दी, देखो मैंने चिट्ठी में लिखा हुआ था कि नहीं भाई हमें उसे नहीं मारना है और हमें कुछ नहीं करना है. That is in favor, maybe in favor of you, so that would not be relevant. Anything that is against you is relevant. And in light of that, the court said that if we see the other evidences, the statement of the Jain brothers, there is not a single statement that indicating that there was a conspiracy. The reasonable ground that there was a conspiracy between VC Shukla and Jain brothers, LK Advani and Jain brothers. Because after this diaries, उनको शुक्ला जैन ब्रदर्स को साथ में लिया होगा, सीबीआई ने थोड़ा उनकी खातिरदारी की होगी, तो फिर उनसे स्टेटमेंट ली होगी. Only thing that on the perusal, this is on the page number 51, on perusal of their statement, we find that some of them irrelevant to the charges of the conspiracy with now concerned other, to the extent that they can be translated into legally admissible evidence, only indicate that Sri Shukla was known to Jain brothers and has gone to the residence on the formal occasion. केवल इतनी ही बात थी उसमें कि वो शुक्ला को जानते थे और उसके किसी ओकेजन्स पे वो लोग गए थे. Then, so far as Sri Advani is concerned, we find that no one has even spoke about him, even in the statement. अडवाणी के बारे में तो उन्होंने जैन ब्रदर्स ने अपने स्टेटमेंट में बोला भी नहीं था. And since the first requirement of the section 10 is not fulfilled, the entries in the document cannot be pressed into service under the latter part. And what is the first requirement of the section 10? That there must be prima facie evidence. There must be the reasonable ground to believe that there is a conspiracy. तो जैन ब्रदर्स की उन्होंने स्टेटमेंट में कहीं कहा ही नहीं कि वो इस तरह की कोई कॉन्स्पिरेसी या कोई चीज थी, तो कैसे बिना ग्राउंड के these statement cannot be used. So there on the last line of the para 50, therefore we have to ascertain whether there is a prima facie evidence affording a reasonable ground to believe about its existence, and because the prosecution has miserably failed to show that there was a reasonable ground to believe, there was prima facie evidence, that is the first ingredient of the section 10. So the latter part would not be applicable. That means the entries would not be read as to prove the conspiracy, because anything said or done can be proved for proving the conspiracy, and that the person was the member of the conspiracy. So these entries cannot be proved to proving the conspiracy in which L. Advani and VC Shukla are part, and there was a conspiracy. And so on that ground also. बाकी ग्राउंड पे भी सारे छूट ही गए, एंड सब लोग छूट गए. ऐसे ही होता है इंडिया में, कोई भी स्कैम हो, बफोर्स हो, रफेल हो. So you know very well. So this is the end of this case. Okay, anything that you want to ask in this case, only these things you have to read. Pehla first on the from first page of this case, on the page number 49, on the page number 49, para, first para, and then third para, fifth para, sixth para, you can read. Then after that, para number 10, that about the case history, and then from para number 46, 49, 50, and 51. So on the section 10, only these paras are relevant, and with this case we have discussed. Is it clear? Any question from this case, CBI versus VC Shukla? बाकी हुआ क्या विनीत नारायण के साथ, वो बात की अलग स्टोरी है. शुक्ला साहब के साथ भी क्या हुआ, that is another story. But we are here not to discuss stories, we are here to discuss law. Yes, Udichi, any question you have from this case?
No, sir. Thank you. Understood.
Yeah. So see, section 10 is very important. Many times question is asked, and these are the important cases from where you can, write your answer beautifully for bisecting the section into the 5 ingredients as it is decided in the Supreme Court 1965 judgment quoted in this VC Shukla case. And writing all the relevant Muhammad Khalid case, Badri Rai case, and Mirza Akbar case, CBI versus VC Shukla case. So that is the end of this conspiracy part. Now on the first portion of this part first of the chapter 2 about section 5, 6, 7, 8, 9, 11. There are two cases that left it. One is about the video conferencing, and another is about the relevancy and admissibility of tape recording statement. So when we discussed section 8, if you remember, I told you that the tape recorded statement is also relevant, but the case in which it is how judiciary explained it, and the reasoning behind that also has been written, so that we will discuss. The first case I'm taking is on the video conferencing. See, uh, the state of Maharashtra versus Prafulla B. Desai, Dr. Prafulla B. Desai, 2003 4SCC 601. This is the name of the case. Now, see the facts of this case. Again, accordingly to five things we have to observe this case. Like, in the last case we have discussed, there was one person, complainant, who filed the complaint where the case started, and his wife was suffering from the terminal cancer. उसको कैंसर था, terminal cancer था और last stage का. So he wanted to save his wife. He took his wife to even America also, and there Dr. Ernest Greenberg of Sloan Kettering Memorial Hospital, New York, USA. These facts you will find on the first page of this case, that is page number 1. यहाँ पे आपको मिल जाएंगे. Okay. And this doctor, Dr. Ernest Greenberg opined that she was inoperable and she should be treated with medicine. इसका ऑपरेशन नहीं कर सकते because प्रॉब्लम हो सकती है, और दवाइयों से ही इसका इलाज होना चाहिए. ओके, देन दे रिटर्न टू द इंडिया. अब इंडिया में आप लोग तो सब जुगाड़ सब करते हैं. सो दिस डॉक्टर A.K. Mukherjee, he despite this opinion operated on her, and when he opened her stomach, ऑपरेशन करते हैं तो स्टोमक को काट के उसमें जैसे खोला ऑपरेशन के लिए, the acidic fluid oozed out from its abdomen, and then Mukherjee closed the stomach, and this resulted into intestinal fistula. Now, अब ये लेडी जब भी कुछ खाती वो सब बाहर निकलता. So this was intestinal fistula, and later on, because of this complexity, she has to be dressing in the single day many times, and unfortunately, finally she died. Okay. Now, this person filed the complaint that this is medical negligence. And on this complaint, what happened that this person, this doctor, he plays some other games also. His name of the patient was not shown in that bill, etc. But we are not going in that story. And now in this proceeding that there was a medical negligence, just keeping the fact simple, he has to prove that despite the opinion of Dr. Ernest Greenberg, the clear opinion that she should not be operated, she has to be treated with medicated, okay, medicine. He want to prove his case that there was a medical negligence. For that, in the trial court, he want to adduce as a witness this Dr. Ernest Greenberg. But doctor has refused to come in India for this deposition. दवाई के लिए मना कर दे, नहीं इंडिया में नहीं आऊंगा. But हाँ, वीडियो कॉन्फ्रेंसिंग के थ्रू आप मेरे से जो भी ओपिनियन पूछना चाहते हो उसकी मेडिकल कंडीशन, यू कैन डू इट. बट छोटे कोर्ट तो लकीर के फकीर होते हैं. अगर वीडियो कॉन्फ्रेंसिंग इट कैन नॉट बी अलाउड एंड इट इज objected by the Dr. Prafulla B. Desai, the opposite party accused. And so ultimately, whether the video conferencing can be allowed under CRPC, is it permissible? Can it be allowed for deposing the evidence is the main question. So the first, about the facts, that it is about the medical negligence, how it has reached. The second is about the case history, that this case reached because the video conferencing was rejected, so it had to High Court and Supreme Court. And the third one is about the issue. The issue is whether video conferencing can be allowed for deposition of oral testimony, or you can say of the witness, or not. The arguments from both the party, the arguments from the complainant side, that because he is not able to come, the doctor is not able to come to the India, and in the CRPC there is no provision by which he can be compelled to come into the India and give his testimony, and so he should be allowed, seeing or taking into the consideration the technological development, etc. These were the arguments. From the doctor side, the argument is that if we see section 273 of the CRPC, the section 273 of the CRPC, that the part in which section 273 fall, if you have CRPC, you can observe it, that it is about evidence to be taken in presence of the accused. And there, if you read this line, it is clear. It is on the chapter, yeah, just give me, chapter 23 of the CRPC, evidence in inquiries and trial. And on the first part, the mode of taking and recording the evidence, there is the section 273. In the case material also, this is quoted by the court on the page number 3, that except as otherwise expressly provided, all evidence taken in course of the trial or other proceedings shall be taken in presence of the accused or his personal attendance is dispensed in the presence of his pleader. So section 273 is clear that evidence has to be taken before the court. Evidence has to be taken in a court before the accused. accused के सामने सारी एविडेंस होंगे, उसके सामने गवाहियां होंगी, उसके सामने डॉक्यूमेंट पेश किए जाएंगे, और अगर उसकी प्रेजेंस डिस्पेंस की जाती कि नहीं, चलो कोई नहीं, आज वो नहीं प्रेजेंट हो सकता, तो उसके प्लीडर के बिफोर, या किसी और केस में वेयर हिज अटेंडेंस इज डिस्पेंस्ड, देन इन द presence of his pleader. But in presence of accused and in presence of pleader, it is required. Now here the argument from the doctor side is that in light of section 273, it is clear that in presence, and in presence means the physical presence. So the doctor Ernest Greenberg has to come into the India and depose. उनको पता था आएगा तो है नहीं. Now, the discussion happened on the true scope of the section 273, that whether the presence means the physical presence, or whether the presence also include that through the information technology, like I am delivering, I am saying this is in presence of you, but I'm not physically present with you. So if this interpretation is given, then the work is done, video conferencing would be allowed. Now, in the every court you will find this VLC and Video evidences through video conferencing. Even the doctor in India, through video conferencing, their testimony is recorded. I was the part of the judicial system, so I saw it. Okay. And from that, the discussion happened, the arguments given on this case from both the sides. From the accused side, some line I'm reading, that section 273 provides for dispensation from personal attendance. In such case, evidence can be recorded in presence of pleader. The presence of pleader is thus deemed to be the presence of accused. The section 273 contemplate constructive presence. This shows that actual presence from the complainant side. This shows that actual presence is not must. This indicates that the term presence is used in this section is not used in the sense of actual physical presence. The plain reading of section 273 does not support the restrictive meaning sought to be placed to the respondent on the word. One must take into note the definition of the term evidence as defined in the Indian Evidence Act. And on that, later on, the court said that yes, video conferencing is allowed under the CRPC. There is no express provision that restrict the video conferencing. Section 273 is talk about the presence that but does not show about the physical presence. And so it includes the presence through any electronic medium, any technological advancement. And to saying this, certain reasoning has been given. One reasoning is that just I read it, that it talk about only the persons but not physical persons. Then on the para number 17, para number 17 also, that the principle has been applied in this court violates considering the analogous provision in the CRPC. In the CRPC, there is provision section 313, 313. And section 313 is an important step in the proceeding, in the trial, where the court asks to the accused for the purpose of enabling the accused personally, कि आपने crime किया नहीं, आप defense लोगे, all these things. The term personally, if given a strict and restrictive interpretation, would mean the accused has to be physically present in the court. But in Basavaraj R. Patil versus State of Karnataka 2000, that you will find in para number 17, that if given a strict and restrictive interpretation, it would mean the physical presence. But it was held that majority of the section had to be considered in light of the revolutionary changes in the technology of communication and transmission and marked improvement in the facility of the legal aid in the country. It was held that the majority, that it was not necessary that in all cases accused must answer by personally remaining present in the court. And now if you see in the trials, the accused is not in the bail step or in other stage, has not to taken to the court, but in the jail itself there is video conferencing, and in the court there is video conferencing, and through that video conferencing many things is done. Many times the bail application is also heard, many times this type of the thing is done, because it's very risky. In the past, in Bollywood movies, so many accused by hooks and crooks, they escape from the police while going to the court. जाते हैं ना कोर्ट, जेल से कोर्ट के बीच में छुड़ा के ले जाते हैं. And in the terrorist case where these many terrorists were kept in the Mumbai, the oval shape jail, everything is done through the video conferencing. But this case is the starting point of video conferencing that reached up to the Supreme Court. Now, in the statute itself, later on you will find it, but it was the time when it started. And so, under section 313 also, it is allowed. So this is on the similar line. When we can allow for the section 313 to the accused has not to be physically present, why not under section 273 for taking the evidences? On the para number 16, the interpretation that has been done, and by the interpretation many words has to be interpreted differently, was laid down in section para number 16, that in the state versus SG Chaudhary, the evidence was ongoing act. The word handwriting in section 45 was construed to also include typewriting. Stage carriage has been interpreted to electric tram car. Steam tricycle include locomotive. Telegraph include phones. Banker book to include microfilm. Take note to include use of tape recorder. Document include the computer database, etc. And so this is interpretation, and one principle is there in the para number 10. Contemporanea exposito ist optima it fortissima in lake. That means the contemporaneous exposition is the best and the strongest law. That means the law has to be interpreted according to the time that is relevant in contemporary time. Strict and restrictive meaning is cannot be provided and should not be provided in the interpretation of section 273. Then the accused said that there are some other difficulties also. One is that it is the virtual reality. The second is that जज साहब क्या होगा जब वो वहां से अगर आपको गालियां देने लगेगा तो दैट मीन इफ यू डीड कंटेम्प्ट ऑफ द कोर्ट, अगर कोर्ट में आके कोई कंटेम्प्ट करता है तो उसको अक्यूज को वहीं पकड़ लिया जाता है. अब डॉक्टर अर्नस्टबर्ग इज सिटिंग इन द अमेरिका. व्हाट वुड डन दैट ही डिड इंसल्ट टू द कोर्ट, कंटेम्प्ट टू द कोर्ट. देखो कितना चाहते थे जज साहब को बहला रहा है. एंड द थर्ड इज दैट व्हाट वुड हैपन इफ ही डिड perjury. Perjury means झूठी गवाही देना. So if in the normal case if a person is doing the perjury and it is noticed, so suddenly the action has taken. So but it is not possible because he is sitting there, he is not in the India. And so these three grounds are also argued. These three things are argued by the accused person. The first, that it is a virtual reality, was rejected by the court. That virtual reality is something that is not impossible. Like when you are sitting here and then there is a spectacles, and though I am sitting here in the room, but I feel that I am on the roller coaster. This is virtual reality. Though I am here and in the room, and then I has to feel that I am on the snow mountain. This is virtual reality. This is not a virtual reality to connect with this. Because of this technology, the word has shrunk. The two person who physically is there, but has connected by this technology, and so it is actual reality. Another thing also, one point was argued by the accused, that what would happen if there is the technical glitches, which में आवाज नहीं जाएगी, समझ नहीं पाएंगे. And so the court said that don't worry about this. We are forwarding to VSNL, Videsh Sanchar Nigam Limited, and they will take care about that thing also. On the case that if there is the perjury or there is contempt, that was also rejected. And so the court allowed that yes, video conferencing can be used for deposition of the evidence by the Dr. Greenberg, who is in America, because under section 32 also, if it is not possible to procure or to secure the testimony of a person because he is dead or he is somewhere else where his presence is cannot be secured without inconvenience, delay, etc. And so the similar situation is there. On the para number 26, you will find all the action, or you can say the precaution that has to be taken while recording the deposition of the Dr. Ernest Greenberg by the court. On the para number 24, Also you will find that about the order, and some line I'm reading, uh, that to be remembered that what is being considered is recording evidence on commission. Fixing of time of recording evidence on commission is always duty. So generally when there is not a witness cannot be um, you know cannot come to the court because he is somewhere else where his presence or he cannot be secured without delay or inconvenience, then the commission is sent. वहाँ कमीशन भेजा जाता है, कमीशन will record the evidence and come back. Okay, and the expense of the commission is borne by the state. So similarly here also the video conferencing, इसका खर्चा भी state उठाएगी. This is on the last line, that undoubtedly the cost of video conferencing would have been borne by the state, and whatever the evidence it has been done, it would be on the oath, etc. So these precaution has to be followed. So this para number 26, para number 24, 25, you read yourself. That would give the all the answer that has been raised. But in the last, the court has allowed the video conferencing by interpreting the section 270 through in the broader sense, in the maxim, according to the contemporaneous time, that presence means the does not mean the physical presence. Presence means the presence by any means. And when the accused presence is dispensed, then his pleader presence is presumed to be the presence of the accused. So similarly, that in section itself, the restrictive meaning is not possible, and so video conferencing is allowed and directed to the court to do the proceeding, the fast. And with that, the this issue was settled. Okay. So any question that you have, guys, with the on this case, any issue, any question, any query, you can ask me.
So
Yes.
how this case is related to Section 8 of Indian Evidence Act?
See, Section 8 is not here said. This is the opinion that is in the question, that opinion of the third party. The Section 8 is not contended that it is relevant under Section 8 or not. But if you talk about that where it is relevant, as the opinion of the the person, that Dr. Ernest Berg, that on that situation, also the doctor operated to prove his negligence. In that sense, it is relevant, but directly it is not said that under 8 it is relevant. Under which section the evidence of the Dr. Ernest is relevant is not contended in the case. It is not in that sense. Okay. Under section 8 is relevant is tape recorded statement. Is it clear?
So, sir, isn't this case is most reliable for CRPC purpose?
No, because the section 273 is basically related to the evidence to be taken, how the evidence has to be taken. This is not directly with respect to the relevancy portion, but yes, with respect to the how the evidence has to be taken, on that aspect it is relevant. So in the CRPC also you can read, but it is related to evidence law, but definitely it is not relevant with respect to the relevancy of the provision, because nowhere it is in the question whether the opinion of the doctor is relevant under which section, or it would be relevant or it would not be relevant. ये तो क्वेश्चन ही नहीं है ना कि डॉक्टर अर्नेस्ट बर्ग ग्रीनबर्ग का जो भी उसका जो डिपोजिशन होगा वो कौन से सेक्शन में रिलेवेंट है या उसमें रिलेवेंट नहीं है, ये इशू में नहीं है. इशू में ये है क्या एविडेंसेस जो है हम वीडियो कॉन्फ्रेंसेस के थ्रू ले सकते हैं. सो as on the general you can say on that respect it is relevant. Okay. Yes. Okay. Now come to the on the contempt. कंटेम्प्ट का क्या इलाज बताया? यू रीड इट 26 कंटेम्प्ट का कोई इलाज नहीं बताया. उन्होंने कहा कि ऑन द ऑथ इट इज डन, व्हेन देयर इज कंटेम्प्ट देन एक्शन विल बी टेकन. तो ऐसा नहीं कि कंटेम्प्ट होगा तो वो किया जाएगा, एक्शन उसके खिलाफ लिया जाएगा. और क्या है, इसमें डायरेक्ट कंटेम्प्ट होता तो डायरेक्ट उसको पकड़ लिया जाता. बट बिकॉज ये कंटेम्प्ट का खतरा है, इसका मतलब ये थोड़ी है कि वी विल नॉट अलाउ. When you drive a vehicle there is always possibility of accident, but that does not mean that you will not drive the vehicle. So ऐसा कोई इलाज उन्होंने ज़्यादा नहीं बताया. Okay. Now the another case that is relevant on section 8 is about tape recorded statement. The name of the case is RM Malkani versus state of Maharashtra. RM Malkani versus State of Maharashtra, AIR 1973, Supreme Court 157. See, this is very interesting case, and the facts of this case is like, you know, the movie plot. Movie में होता है ना. So what happened that there is this person Jagdish Prasad Ram Narayan Khanderwal. There was a person who admitted to the hospital of the gynecologist Dr. Aditya. किसी एक हॉस्पिटल में भर्ती हुआ बिकॉज उसको अपेंडिक्स था. एंड जब उसको पेन था देन ही वाज डायग्नोस्ड, एंड in the diagnostic report he was found to be suffering from acute appendicitis. यानी appendix होता है ना जो हमारा जो लास्ट दैट इज उसकी प्रॉब्लम हो गई थी उसको. एंड सो ही हैज टू बी ऑपरेटेड, ही हैज टू, दैट appendix has to be removed. Okay. Now Dr. Aditya kept the patient under observation. After 24 hours the condition of the patient became serious. Dr. Santilal J. Mehta was called. His diagnosis was acute appendicitis with generalized peritonitis. These are some medical terms. After that Dr. Aditya, operated on this patient, Mr. Jagdish Prasad, and the operation go unsuccessful. The patient had become, the appendix, according to Dr. Aditya, had become gangrenous, and the patient developed paralysis of ileum, and unfortunately he died. Okay. Now the question is that hospital intimated death as the paralytic ileum and peritonitis following the operation of acute appendicitis. The police station then asked for the inquest report. There used to be the coroner, CORONER, and this coroner duty is to do the inquest. Inquest होता है मौत के कारण का पता लगाना, the causes of the death. Mr. Malkani was at the crucial time was the coroner of Bombay. He was the person who has to do the inquest report, to do the inquest and submit the inquest report. So he allowed the disposal of the dead body also. Dead body भी चली गई. And then he has to give the inquest to the police station, and then he thought that he can exploit this situation, और उसने डॉक्टर आदित्य से ब्राइब मांगने की कोशिश की. And he demanded 20,000 rupees उस समय. भैया आपका मेडिकल नेग्लिजेंस था, that I will write in the inquest report, action will be taken, प्रैक्टिस से बाहर हो जाओगे, मार्केट खराब हो जाएगी, so many things. So he demanded 20,000 rupees as a bribe for making such type of the report. Otherwise he will make the report against Dr. Aditya showing that there was medical negligence. Okay, I'm making facts simple. Then Dr. Mutwani, who was also in the scene. So Muktwani also made to this appellant corner. उन्होंने कहा कि नहीं नहीं इतना तो ज़्यादा है. उन्होंने कहा कि नहीं 10,000 पे कर लेते हैं. तो 10,000 भी it was not settled, and then many round of discussion done etc. Then it was settled on 15,000 rupees कि भाई पुलिस को भी देना पड़ेगा, सारा मामला सेटल करना पड़ेगा. And then this person Mutwani, they informed to the police also कि सर ऐसा ऐसा हो रहा है, and this coroner, who is the person to make the inquest report, is demanding the bribe. Otherwise he is threatened us to make the report adversely. So the police officer on the para number 10, you will find that the police officer and Dr. Mutwani met at the residence of Dr. Aditya about 4 p.m. and the raiding मतलब police party जो raid मारती है, connected the tape recorders to the telephonic mechanism of Mr. Dr. Mutwani. Mutwani dialed the appellant residence and spoke with the appellant in the presence of police officer. The conversation was also recorded on the tape. टेप रिकॉर्ड कर दिया उसके फोन से. उसके कहने पे मुतवानी ने बात की डॉक्टर से, कॉर्नर से, और ये सब हो रहा है जिससे रिश्वत मांगी जा रही है डॉक्टर आदित्य के घर से. और फिर जो है वो सारा स्टेटमेंट रिकॉर्ड कर लिया. इट वाज अरेंज्ड टू टॉक डॉक्टर मुतवानी वुड पे द अमाउंट ऑफ अ प्लांट ऑन October 12, 1964. And Mutwani was asked to take letter addressed to the appellant stating that he was returning the loan of 50. देखो कितना स्मार्ट था वो. And this appellant RM Malkani, उसने कहा कि आप 15,000 रुपए लेके आना घर पे, उसके साथ एक लेटर लिख के आना कि आपने लोन लिया था और वो लोन चुका के जा रहे हो. वेरी स्मार्ट. तुझे क्या पता कि पीछे से तो खेल हो गया, स्टेटमेंट सारी होगी. And then this person, Mr. Mutwani, went to his office, his house also. He was not there, and his wife was there, and he gave the money to that. Then, this person was charged, and investigation was done, and this tape recorded statement and other evidence was also adduced before the court. Now the contention of the accused RM Malkani is that, sir, this is unfair. How can record someone this telephone? It is contravention of section 25 of Indian Telegraph Act. It is offense. And the evidence that is secured through the illegal means, how that cannot be allowed. So that is one ground. Then he say that because it infringes Article 20 Clause 3, that no one can give the evidence against himself, self-incriminating fact. It violates Section 21, right to our life. कल को हम तो ऐसे बात ही नहीं कर सकते, आगे तो रिश्वत ही नहीं मांग सकते. So it is the violation of Article 20 Clause 3, Section 20, Article 23, Section 25 of Indian Telegraph Act. And so these tape recorded statements should not be allowed. Because if it is allowed, this is, in this case, the tape recorded statement is allowed, it would be relevant because it shows about, if you remember that what are covered in that, the tape recording in the, Section 8, the motive. And so in the conversation, the motive was also clear. कि आपको पैसा देना है, otherwise मैं inquest वो बना दूंगा. So why the bribe was taking? Because there was motive. And the another thing is preparation. So this shows preparation also, that you have to give this amount to my house with the letter having that you have written the loan. But this person RM Malkani is saying that no, tape recorded statement, no, this is not allowed because it is violation of section 25 of Indian Telegraph Act. And so the main issue is that whether the tape recorded statement is relevant and admissible or not. Okay. The arguments from the accused side is that the evidence illegally obtained in contravention of section 25 of Indian Telegraph Act, and therefore the evidence is inadmissible. The second argument, that the conversation between Mr. Mutwani and the appellant, which was recorded on the tape, took place during investigation as much as Mogvi was the police officer, was asked Dr. Mutwani to talk, and therefore the conversation was not admissible under section 62 of the Code of Criminal Procedure. The third argument is that the appellant did not attempt to obtain the gratification. The fourth is, it was said that the sentence of 6 months, this is about the sentence itself, we are not relevant about that. Okay. Because he was sentenced, and then in default of sentence, in default of fine, rigorous imprisonment also, and then he approached to the Supreme Court. So this is the case history. Now the question is, the three important thing here, that whether in light of section 25 violation, though definitely it is the violation of section 25, because this tape recorded statement is not in accordance with the procedure established under the Indian Telegraph Act, so it is in violation of section 25. Whether in violation of section 25 also the tape recorded statement can be admissible. The second thing, that is it in the violation of Article 20 Clause 3 or Article 21. And in the nutshell, you can say that in light of these arguments, whether the tape recorded statement would be admissible or not. Now on the para number 19 and 20, you will find the discussion with respect to section 25 of Indian Telegraph Act. That in present case, the High Court held that the telephone call put by Dr. Mutwani to the appellant was tapped by the police officer, and therefore there was the violation of section 25 of Indian Telegraph Act. But High Court held that tape recorded conversation was admissible in evidence in spite of violation of Telegraph Act. Court admitted, yes, it is violation of section 25. So that would be another thing. But despite it is in violation of section 25 of the Telegraph Act, it is admissible. On the para number 20, again you will find this discussion. In the middle of it, I am reading. The substance of offense under section 25 of Indian Telegraph Act is damaging, removing, tampering, touching machinery, battery line, or post of interception, acquainting oneself with the content of any message where a person talking on the telephone allow another person to record it or to hear it. It cannot be said that the other person who is allowing to do so is damaging, removing, tampering, touching machinery, battery line, or post of intercepting or acquainting himself with the content of any message. There was no element of coercion or compulsion in attaching the tape recording to the telephone, and there was no violation of Indian Telegraph Act. The High Court was in error on that point. So Supreme Court has said that if you see section 25, section 25 says that there is the damaging, there is removing, there is tampering, touching, etc. Here, on the telephone line, at one side is Dr. Mutwani, on the another side is RM Malkani. So Dr. Mutwani, this was done with the permission of Dr. Mutwani. एक तरफ उनके permission से सारी चीजें हुआ. And so because it was on the permission with the Dr. Mutwani, there was no force, there is no coercion, etc. And so it is not said that this was in violation of the section 25 of the Telegraph Act. High Court ने तो कहा कि section 25 का violation है, then also it is admissible. But Supreme Court ने कहा no, इस section 25 का वायलेशन भी नहीं है, एडमिसिबल तो है ही है. Then on the para number 21, certain judgments are referred by the court that in as Pratap Singh versus the state of Punjab, court accepted that conversation or dialogue recorded on a tape recording machine is admissible evidence. In Nagri case, the conversation was between Nagri and Sheikh, or Nagri was accusing of offering bribe, was also admissible. On para number 22, that this is because previous statement furnished by tape recording conversation, the tape itself became the primary and direct evidence of what has been said and recorded. Then on the para number 13, certain precaution that has to be taken with respect to the tape recording statement. It is not as shown in the movie कि फिर कोई भी tape recorded statement ले आए, जज साहब ये सुनो, ऐसा नहीं होता. वो इन्वेस्टिगेशन के दौरान हो, उसमें precaution ली जाती है that it has not been tempered etc. So that precaution is in the section 23. Tape recorded conversation is admissible. Problem is, agar simply suppose there is a conversation, one-to-one conversation between Dr. Mutwani and the appellant, उसमें आपने tape recorded कर लिया होता कहीं भी छुपा उपा के, that is allowed. But and that is also not in violation of section 20 clause 3. वो self incriminating अलग चीज होता है कि आप force करवा के accuse से ही करवाओ. There is no force on the the RM Malkani at that time. Okay. The another thing is that the question is that ये tape recorded attached था phonic से, और उन्होंने कहा कि phone को tap करना is punishable under section 25, but fortunately Supreme Court has said that no, it is not. Now see, on the page number para number 23, the Supreme Court has said that while admitting the tape recorded statement, certain precaution has to be taken. The tape recorded conversation is admissible provided first the conversation is relevant to the matter in the issue. So it has to be relevant to the matter in the issue. So suppose if it is with respect to the motive, so under section 8 it would be relevant. अगर कोई motive बता रहा है या motive से related है, उसका tape recorded statement होगा. अगर कोई bribe मांग रहा है या उसका प्रिपरेशन दिखाता है भाई ऐसे आप जाना और मुझे ब्राइब दे देना, तो वो उसके प्रिपरेशन को शो करता है. ओके. अगर वो और किसी कंडक्ट का भी उसमें रिकॉर्डेड चीजें हैं तो वो उसको शो करता है. सो वट एवर बी, it has to be relevant by any of the section, like in the Dr. Ernest case also, video recording conference is allowed. But whether the doctor evidence is relevant, that was not in the question in that case, but that would be relevant for showing the condition of the patient. Okay. So under any other section that may be relevant. So here also, court is saying that tape recording conversation is admissible provided that conversation must be relevant. कि आप उसमें क्या दिखा रहे हो, कि मोटिव दिखाने के लिए आपने ये कहा है कि नहीं सर उसका मोटिव था और इसकी प्रिपरेशन थी, इस तरह से ब्राइब लेंगे, as it contented in this section, and to showing the motive and the preparation under section 8 this statement was done. Secondly, there is identification of voice. Voice has to be identified कि ये voice RM Malkani की है. Thirdly, that accuracy of the tape recorded conversation is proved by eliminating the possibility of erasing the tape record, that it has not been doctored. Contemporaneous tape record is a relevant conversation. जो कंटेम्परेनियस है, जो होल इंसिडेंट को दिखाता है, लाइक इन दिस केस में भी हुआ है, दैट इज रिलेवेंट एज a contemporaneous tape record of relevant conversation is relevant fact and it is admissible under section 8 of Evidence Act. It is res geste, section 6 भी आ जाएगा. It is also comparable to photograph of the relevant incident, and the tape recording conversation is therefore relevant and admissible under section 7 of the Evidence Act is also. The conversation between Dr. Mutwani and a appellant in the present case is relevant to the matter in issue There is no dispute about the identification of voice. There is no controversy about any portion of the conversation being erased and mutilated. The appellant was given full opportunity to test the genuineness of the tape recorded conversation. The tape recorded conversation is admissible in the evidence. So the court said the tape recording conversation is admissible, though it has to be related with anything that is relevant. Like if it is the whole incident, motive, etc. So under section 7, it will be relevant. If it shows the whole incident that is happening, so it under res geste it would be relevant. Okay. It is also as the photograph of relevant statement. So under many sections, the tape recorded statement, the whatever recorded in the tape would be relevant, but yes, it is admissible even if it is recorded through the phone where there is no coercion by one of the party, when there is no force, then also it would be not violation. Then the two other contention that was raised, that whether it is with the violation of section article 20 clause 3 or article 21. On the para number 30, the court said that the admissibility of tape recorded evidence offended article 20 clause 3 and 21 of the constitution was argued. The submission was that the manner of acquiring the tape recorded conversation was not procedure established by law, and the appellant was incriminating. The appellant conversation was voluntary. There was no compulsion. The attaching of tape recording instrument was unknown to the appellant. The fact does not render the evidence of conversation inadmissible. The appellant conversation was not the extract under the pressure, duress, and compulsion. So this statement that this tape recording statement has of Mr. R.M. Malkani was not that there was a pressure on R.M. Malkani ki aap kaho ki bribe lunga. There was no pressure, there was no compulsion on R.M. Malkani. And so these are not in violation of section 20 clause 3 and 21. If the conversation was recorded on the tape, it was a mechanical contrivance to play the role of the eavesdropper. In R versus Letham, it was said it is matter not how you get it. If you steal it even, it would be admissible in evidence as long as it is not tainted, inadmissible confession of guilt, even if it is illegally obtained. So one case is referred that even if how you secure that thing, it is not relevant. In the section 24 of your Evidence Act, you will read some more also. Like in one movie, the Hema Malini was the police officer, and after drinking this accused, she secured the confession. So by any means you secure the confession, that would be relevant if it is not tainted. Okay, so that is the thing. And then on the para number 31, the court has observed that there is no scope for holding that the appellant was made to incriminate himself. At the time of conversation, there was no case against the appellant, because the incriminating fact is also when there is a case against the person. So at the time when he made this statement, there was no case against Mr. R.M. Malkani. He was not compelled to speak or confess. Article 21 was invoked by submitting the privacy of the appellant conversation was invaded. The Article 21 contemplate procedure established by law with regard to the deprivation of life and personal liberty. The telephonic conversation of innocent citizen will be protected by the court against the wrongful and high-handed interference by taping the conversation. The protection is not for the guilty citizen against the effort of the police to vindicate the law and prevent the corruption of the public servant. And it must not be understood that court will tolerate the safeguard for protection of the citizen to be imperiled by permitting the police to proceed by unlawful and irregular method. In present case, there is no unlawful or even irregular method to obtaining the tape recording of the conversation. So see, another angle you can see it, that even at one side, the court is saying that this is not the proper, it is, yes, it is the violation of the privacy. and court will not allow. But we are allowing it because it is not applicable to the guilty, but that is not general rule who are doing the corruption to the public servant. So it's saying that we will take care, and even in the future also we will say that the police will not do such type of irregular thing, but also allowing that. So in this particular case, they are allowing the tape recording statement, without, in that irregular manner. Proper procedure that you have to take permission, etc. The different thing are there. So just to, the corruption, the court also has allowed it. But in the nutshell, this is not in the violation of section 20 clause 3 and 21 in that perspective. So with this, the tape recorded statement is admissible, and the tape recorded statement has to be relevant. If it is related to the motive, it will relevant to 8. If it is related to the previous preparation, the whole preparation, how the corruption, how the bribe was given, so it is the evidence of the the preparation, so it is relevant under section 8. If it is showing whole the incident, suppose defamation ka hi pura incident chal raha hai, so it is relevant under rest geste. If it is it may be relevant under section 7 also. It is that like the photographs, or under section 9 also it would be relevant. So under various section it can be relevant, but yes, it is admissible. From these two cases, from Prafulla Desai case and this case of RM Malkani, we have learned that these technical advancement in the criminal system also has allowed by the court, even because the time when the criminal procedure court, when the section 273 was drafted in 1973, there was no such concept of the video conferencing. And so the interpretation has to be given by the court, that is as per the contemporary time, as said in that case also. And so these technological advancement, these information technology tool has to be allowed, and these two cases are just the example that how the video conferencing and the tape recording statement was made to be the admissible. With this, the earlier two cases that are in our case material also we have discussed. So with this we have discussed these 5-6 cases. The first one is state of Maharashtra versus Prafulla B. Desai. The second one is RM Malkani versus state of Maharashtra. The third one is Mirza Akbar versus Emperor. The fourth one is Badri Rai versus state of Bihar. The fifth one is Mohammad Khalid versus state of West Bengal. The sixth is CBI versus VC Shukla. Okay. Do we have time, or should we finish our class now? Yes, guys. So this is the end of the cases. Time is 3:30. It is up to the 3:50. Huh? Can we discuss some more things also? Bolo bhai. Okay, no, Ajay, just a few things we can discuss. I will not discuss some important thing, but just something that is, see, after that, if you see the second part of the chapter 2, it is about admission, confession, etc. Section 12, 13, 14, 15, 16 are not there. So these section we can discuss a little bit, because as such syllabus mein to nahi hai, but we have to be because in the exam, the competition exam, they can be asked. So just I'm making you aware. Section 12 is talking about, so suppose there is a civil case, and in the civil case there is a suit, and in that suit that regarding the amount of damage, कि आपको कितना मुआवजा मिलना चाहिए. So in that case, the fact that enable the court to determine the amount of damage would also be relevant. Section 12 कहता है कि अगर कोई सिविल केस में ये क्वेश्चन है कि कितना डैमेजेस मिलना चाहिए, तो ऑल दोज फैक्ट्स दैट enable the court to determine the amount of damage would also be relevant. ये सिविल केसेस में डैमेजेस के केस में होता है. सेक्शन 12 एंड सेक्शन 25, सेक्शन 12 एंड 55, 12-55 दोनों रिलेवेंट होते हैं, वो दोनों करेक्टर से. सो इन दैट केस समटाइम द करेक्टर is also relevant, because if you remember that in case of damages, it is also depend that if you are habitual offender of doing that thing, then amount of damage is increased. So in that sense, the character of the past incident would also be relevant under section 12 and section 55. Basically, if you see that all the facts that may not be relevant to the case, but because these facts are helpful for determining that how much damage has to be awarded, would also be relevant. Then section 13 is talking about the existence of right or custom. When there is the issue related to the existence of a right or a custom, आपको किसी पॉन्ड की लीज है या नहीं, या आप किसी कमरे में रहते थे या नहीं, या आपको किसी दुकान आपने जैसे लीज पे ली हुई है कि नहीं. तो when there is such question, any transaction by which the right or custom in the question was created, claimed, modified, recognized, asserted, denied, or which was inconsistent with its existence would also be relevant. Particular instances in which the right or custom was claimed, recognized, exercised, or in which it was exercised, was disputed, asserted, or departed from. So, like the example is there in the illustration, that the question is whether A has right to fishery, a deed conferring the fishery right on the A's ancestor. क्वेश्चन में है कि ए को किसी पॉन्ड में फिशरी का राइट है या नहीं है. देयर इज अ डीड इन विच द फिशरी राइट इज गिवन टू एज एंसेस्टर, उसके बाप दादा किसी को दिया हुआ है. सो ए मॉर्गेज ऑफ द फिशरी बाय एज फादर, a subsequent grant of fishery by A's father irreconcilable with the mortgage, particular instances in which A's father exercised this right or which the exercise of right was stopped by A's neighbor is also relevant. So suppose किसी नेबर ने उस पर जो है ऑब्जेक्शन किया हो, या कभी उसने कोर्ट में जाके ऐसे क्लेम किया हो, these would also be relevant with respect to that whether they have the right to fishery or not. Section 14 and 15 are very, very important. Section 14 and 15 related to psychological fact, that whether there was a state of mind or the body or the bodily feeling, whether it was accidental or not accidental. जैसे there was a question that A has कोई बंदा है, उसने अपनी वाइफ का इंश्योरेंस करवाया, and after that his wife died. And the question was, the issue was whether she was died in the accident or is it was intentional. कार में गए, कार में जो एक्सीडेंट हो गई, बंदा बच गया लेकिन वाइफ मर गई. And now it is shown that earlier also उसने 2-3 शादियां ऐसे कि इंश्योरेंस किया, कार में एक्सीडेंट होता है और वाइफ मर जाती है, बच जाता है. So this shows that it was not accidental, it was intentional. Section 14 or 15 is talking about that psychological fact. Section 14, I'm reading it, that fact showing existence of state of mind or body or bodily feeling. Fact showing existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will, goodwill toward any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of such state of mind, body or bodily feeling is in issue or relevant. So the intentional, the psychological fact है, जो intention वाला part है कि whether it was with intention, with knowledge, with reason to believe, ये सारा section 14 और 15 के अंदर ही prove होता है. Now explanation 1, a fact relevant is showing the existence of relevant state of mind shows that the state of mind exists not generally but in reference to the, but suppose if you are showing that he was intended to kill, so you cannot say that generally he is in the state of mind to kill the other person. That has to be shown particularly that in this particular incident, he has the intention to kill the person. It was not the accident. The other explanation is by but where upon the trial of a person accused of an offense, the previous confession commission of by the accused of a offense is relevant within the meaning of this section, the previous conviction of such person shall also be relevant fact. This is something different. If you remember section 75 of the Indian Penal Code, enhanced punishment there, etc., that it's talking about that in the trial of a person, the previous commission of the accused is also relevant. The previous conviction of such person shall also become a relevant fact. Now the illustration you will see the illustration and explanation would not increase the scope of the section. Section के अंदर जो लिखा हुआ है वो ही उसका प्रॉपर स्कोप है कि वो उसका कितना मीनिंग होगा. इलस्ट्रेशन और एक्सप्लेनेशन उसके स्कोप को नहीं बढ़ाते हैं, वो केवल उसको एक्सप्लेन करते हैं. अब सी सम इलस्ट्रेशन दैट वुड बी वेरी वेरी हेल्पफुल. One, A is accused of receiving stolen goods, knowing them to be stolen. It is proved that he was in possession of a particular stolen good. The fact that at the same time he was in the possession of many other stolen articles is the relevant as tending to show that he knew each and one of that article. A पे there is allegation on A कि उसने चोरी का सामान जो है वो रिसीव किया. ए कोई दुकानदार है, उसने चोरी का सामान खरीदा. अब क्वेश्चन फॉर अट्रैक्टिंग सेक्शन 410 ऑफ द इंडियन पिनल कोड, दो चीजें, एक तो आपने चोरी का सामान लिया और दूसरा आपको पता था कि ये चोरी का सामान. नाउ हाउ टू प्रूव दिस इंटेंशन, ये तो बड़ा डिफिकल्ट है. यू कैन नॉट गो इनसाइड द माइंड ऑफ द पर्सन. बट ये चीजें कि और भी जो सामान उसके दुकान में थे वो सारे चोरी के थे. So the fact that at the same time he was possession of many stolen article is relevant as to tending show that he knew each and all of article which he was in possession to be stolen. So this giving the reference with respect to his knowledge, that he has the knowledge that these articles, these items he is purchasing are stolen. Okay, so these illustration you can read, you will enjoy this section. Now come to the section 15. It is fact bearing on the question whether act was accidental or intentional. So whether it was accidental or intentional, again it related to mind, it related to psychological fact. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that such act forming the part of the series of similar occurrence, each of which the person doing the act was concerned, is also relevant. A is accused of burning down his house in order to obtain money for which he was insured. A के ऊपर इल्जाम है कि उसने अपना घर खुद जला लिया ताकि इंश्योरेंस का पैसा मिले. The fact that A lived in several houses successively, वो पहले कई घरों में रहा है, उन घरों का इंश्योरेंस करवाया है, उन घरों को जला दिया है, इंश्योरेंस का पैसा लिया, it's also relevant that this fire was not accidental, it was intentional. Okay, how much weightage it would be given, that is different thing, but this thing you can prove that successfully also he did that this thing. And then there is next section 16, that is important. Existence of course of business when relevant. When there is a question whether a particular act was done, the existence of the course of business according to which it naturally would have been done is irrelevant. So the course of business is relevant. Like if there is a question that the message is delivered to you or not, and in your through the WhatsApp. Now the someone is also going through the WhatsApp by the court. So suppose in the message it is shown one line, that means it is by this person, then two right sign, that means it is delivered, and then blue right sign, that means you read it. So अब इसमें जो illustration है वो पुराने जमाने की, अब 1872 में they never have this expectation कि इस तरह का आएगा. So the question is whether a particular letter was dispatched. The fact that it was ordinary in course of business that all letter put in a place to be carried to the post, and the particular letter was put in that place, are relevant. The question is whether a particular letter reached A. The fact that it was posted in due course and was not returned to by the dead letter office, it was relevant. कि एक पर्टिकुलर लेटर है वो डिस्पैच हुआ कि नहीं हुआ, तो ऑर्डिनरी कोर्स में जब आपने उसमें डाल दिया तो प्रोसेसर के थ्रू वो चला गया होगा. एक लेटर जो है वो ए को डिलीवर हुआ या नहीं हुआ, वो लेटर जो है ना तो डेड लेटर से वापस आया. इफ लेटर इज नॉट रिसीव्ड इट हैज टू कम बैक टू द पर्सन हु पोस्टेड इट. सो वापस भी नहीं आया तो इसका मतलब ही वाज डन. So these section 16 is about the course of the business. Similarly, you can apply to the other technological tools also, other things also. This. So with that, section 12, section 13, 14, 15, 16, we have discussed. Section 12 talking about that those facts that are helpful for determining the quantum of compensation, the quantum of, damages are relevant. Section 13, that if we talk about the rights and the custom, then all the particular transaction, all the particular things where it is claimed, where it is denied, rejected will also relevant. Section 14 and 15 about when there is a question whether it is accidental or intentional, where there is the knowledge, where there is intention, where there is good faith, where there is ill will, etc. Then other circumstances that showing or that thing would also be relevant. Section 16 about the existence of the course of the business would also be relevant. So with that, this is complete. Now the next part that we will discuss is about the second part of the topic or chapter 2, that is stated relevant fact. And here it is subdivided into 3: admission, confession, and dying declaration. Admission, section 17 to 23, confession 24 to 30, and dying declaration 32 clause 1. So this we will start in our next class. First we will take with the admission. First we will discuss section 17, 18, 19, 20, 21, 22, 23 one by one, and then we will discuss cases that is based on admission. Then we will discuss confession, and then the cases on the confession. So with this, from my part, the today lecture is over. If you have any question, if you have any issue, any query with respect to our today's discussion, you can ask me. I'm giving you 2 minutes.